Hi, and welcome to this immigration law drafting webinar. Today, I'm actually conducting some training for a number of solicitors on immigration law drafting. And what I thought I would do is record a special version of that webinar to share on my YouTube channel. So today in this webinar, we're going to cover drafting representations, skeleton arguments, and various types of grounds. I'm going to refer to a number of resources in this webinar, and I've put the links below the description of the video. What I'm going to also try and do is get my slides loaded onto the Number 8 Chambers website. So if you want a copy of these slides, have a look at the news section on the Number 8 Chambers website. So let's have a look at what we're going to do today. We'll start with my PIPES principles and start by the difference good drafting can make. You know, good drafting can make a huge difference to your client because it can mean that an application can be granted at first instance by the Secretary of State or the entry clearance officer. Good drafting may help you win an appeal or say a judicial review application. Certainly I remember challenging an unappealable Article 8 decision on the failure of the Secretary of State to properly consider insurmountable obstacles. And I took the judge to the paragraph in the decision on insurmountable obstacles, and he said, yep, I agree with you, Mr. Pipe. There's not much reasoning by the Secretary of State. But let's go back to the representations. What was put forward as part of the claim? And when I took him to the representations, there was very little there. So the lack of detail in the representations made a big difference to that claim. Secondly, then, the danger of cut and paste. You know, we're all busy lawyers and representatives, and we all use cut and paste. And it's helpful when we have similar claims. But the danger is cut and paste can lead to long, fat documents that have a lot of irrelevant material, and the reader sometimes zones out. Often, sometimes it can lead to irrelevant material there. I've got some representatives I've seen where every time a new Article 8 case comes out, they add it to their standard submissions and the document becomes ridiculously large. And sometimes there's out-of-date material or wrong material, which could damage your client's case. So we've got to be careful with just cut and paste and standardized submissions. My third principle is long doesn't necessarily mean good. Just because something's long doesn't mean it's good. Now, as we go through this webinar, we need to cover our bases. We need to make sure we address the relevant rules. If we need to raise things like human rights, we need to make sure we do that. If there's alternative basis of the claim, we need to deal with the evidence. But just long submissions doesn't mean it's good stuff. Look at those quotes from Justice Susan Glazebrook. I think she's a High Court judge in New Zealand in this paper, and I've linked it there. Being concise is not the same as short, although where possible, short is a good idea. Being concise means getting rid of unnecessary detail. If you want to put it in simple language, trim the fat. Make sure you've got the essential stuff there. And fourthly, get the law right. You know, we practice in one of the most difficult areas of law, immigration law. Rules are changing, it seems, on an overnight basis. You wake up in the morning and there's been a new statement of changes, perhaps a new policy paper, a new reported decision, which changes everything. And it's important we get the law correct. I still see sometimes in spouse cases references to Rule 281. And we know Appendix FM, we're celebrating, I say celebrating, it's probably the wrong phrase, but we're remembering 8 years of Appendix FM and the changes in July 2012. But still I see references to the old pre-2012 rules. We need to get the law right and address the correct legal provision. So when you're drafting, whether it's a skeleton argument, whether it's grounds, or whether it's representations, make sure you're addressing the correct law. And be clear and avoid legalese, avoid legal jargon. Sometimes I think lawyers feel like they need to earn their crust by using big, fancy, flowery words. It's not necessary. One of the common themes you're going to see as we look at representations, as we look at skeletons, as we look at grounds, is this clear and conciseness. So look at Susan Glazebrook. She says this: speak English, not lawyer, in your submissions. I think sometimes there's a different language known as lawyer. We need to speak clear, plain English. And then she says this: meet the usual rules of good writing. Use short sentences, one idea per paragraph. Keep adjectives and literary flourishes to a minimum. An argument can ironically appear weaker if it is adorned with hyperbole and adjectives. So, be straightforward and matter of fact, clear, plain submissions. Then she says this: make sure your submissions are logically structured, pleasingly arranged, with plenty of good road signs. Something as I've been preparing this webinar that has come across to me is how I arrange my written work. Is it pleasing to the eye? Is it easy to read? If it's all in tiny font, I had once a judge said to me, look, Mr. Pipe, us judges are getting a bit older. Sometimes I struggle with this 10-point font. Is your font big enough? Is it pleasantly arranged? Are there road signs? So are there headings which are clear road signs to the reader, and you're taking them on a path that reaches the destination that you want to reach? If that's an allowed application or allowed appeal, you're saying A plus B plus C gets you to this destination. And she says this: typos make you look sloppy. Inaccuracies in the facts and the law are even worse. Get someone to check your work. You can get too close. I've done it millions of times. I've sent off a skeleton or some grounds to a solicitor, and it's only later then I see typos in my own work, because often when we read our own work, we read what we think we meant rather than what we actually typed. So it's important sometimes to get somebody to check your work or read over it. I sometimes read it backwards, read it from the bottom to the top, because sometimes it helps me spot the typos in my written work. But language is powerful. And sometimes we can harness, or this is what we want to do all the time, we want to harness language in a way that presents our client's case in an attractive way that's going to lead to the outcome we want. The famous master of the rolls, Lord Denning, is well known for his judgment. And in Lloyd's Bank and Bundy, he says this: this is his opening paragraph. I can't do the accent, but Broadchalk, forgive me, is one of the most pleasing villages in England. Old Herbert Bundy, the defendant, was a farmer there. His home was at Yew Tree Farm. It went back for 300 years. His family had been there for generations. It was his only asset. But he did a very foolish thing. He mortgaged it to the bank, up to the very hilt, not to borrow money for himself, but for the sake of his son. Now the bank have come down on him. They have foreclosed. They want to get him out of Yew Tree Farm and sell it. They have brought this action against him for possession. Going out means a ruin for him. Powerful language from Denning there. You're already wanting Bundy to win against the bank, and you can see which way Denning is going. Notice his use of short, clear language. All right, he used the word foreclosed, and then sometimes needs to be legal terminology, but it's short, plain, clear, powerful language, and you can't help but be drawn in to this attractive account, and it makes you want to see Bundy win. So the power of language is emphasized there. So let's start our first of 3 sections looking at representations, and you'll see my subtitle there: representations, laying the foundation, because representations are the important foundation for a case. Good representation submitted in support of an application can make a huge difference. Obviously, we want an application to be successful, and even if it's not successful, the representations can make a huge difference at appeal or on an application for judicial review. Now, I've borrowed here from HJT's wonderful resource, Mastering Immigration Law. And I've put a link in the description below how you can get hold of this brilliant resource is the online resource and the paper manual. So this is what HJT say. Complete the formalities correctly. Writing form of a letter with a salutation. Client's full name, date of birth and nationality, and explain the stage the case has reached. So is this an application? Are you sending further evidence? Is this a variation application? You've already got an application in and you're varying it. Make it clear. Refer to the documents being enclosed, and they say a schedule is the clearest way to do that. Do you know, when I come to judicially review decisions and say, well, the Secretary of State hasn't taken into account evidence, one of the best things I ever see is a schedule in the representations, because I can say, look, Judge, look at all those documents that were there to show the genuine and subsisting nature of the relationship. They haven't been looked at all. So a schedule is really good. Briefly set out all the relevant introductory matters. So the factual basis of the case. So what are the facts? A summary of the facts. That's what we saw Denning do in that quote there, a summary of the facts. Make it clear the leave you're applying for, who you're applying for, what type of leave are you applying? Are you applying within the rules? Are you applying for refugee status? Are you applying outside of the rules? Are you applying under a policy? If you're waiting for further evidence and you want them to pause and wait for making a decision, make that clear. Forgive the small text, but then make your substantive representations. What are the legal propositions? Now, I think the way I would do this, if you're applying under the rules, set out the different rules you have to meet. Or if it's under the Refugee Convention, you could say, well, this is the convention reason. This is the fear of persecution. This is the risk upon return. This is the country evidence. This shows that internal relocation is not available. So set out the different legal principles and then apply the facts to the case. Show, look, these are the facts that show this is met. Here is the evidence that shows the maintenance requirement is met. So apply the facts and the evidence to those legal criteria. Though if there's been any errors in the case, that's where you point that out. Point out any errors. Cross-refer to the sources. So say, here is the evidence of the financial provisions. Look at this country material here. Here is a relevant piece of case law which applies to this. This is how you should assess third-party support, for example. And then what about other material? So say you're relying on a Home Office policy. You may be, say, applying under the carers policy. Now, often the Home Office won't look at their own carers policy unless you point it out to them. So say, look, actually, we're caring for an elderly British relative. Here's the carers policy. I satisfy this carers policy. And then if there are any other issues you want them to address, I often think it's important to address alternatives. So if you're applying for refugee status, is there a standalone claim for humanitarian protection? Is there a claim of very significant obstacles to integration under 276 ADE? Is there a standalone Article 8 claim? An important issue at the moment is in terms of getting a right of appeal in, say, cases where there's a human rights claim. So if you're making a domestic violence claim, also address why it's a human rights claim. So the Secretary of State will engage with that and you can secure a right of appeal. And again, look at the general criteria. And again, this is something that'll come up time and again. Logical structure, concise, precise, correct, plain professional English, ethical standards, and being persuasive. And just something HJT often also point out is explanations for conduct that might antagonize the Home Office. So if you've got somebody who overstayed in the United Kingdom and returned to apply for entry clearance, address their overstaying. Say, look, this is not a case that should engage 32011, and here is why. So address the elephant in the room. So those are representations. What about skeleton arguments? Now, skeleton arguments are really important. They're important because they set the tone for an appeal. If you can get a skeleton argument before the judge, it's going to set the tone. I'll give you some quotes to show how that does that now. And it gets the judge in your mode of thinking. And also, it goes some way to writing the judgment. You want your skeleton argument to form the basis of the judge's judgment in your case. And we know with the reform to first-tier appeals, which has been fast-forwarded as a result of the COVID pandemic, the appeal skeleton argument has now become very important in appeals before the first-tier tribunal. So skeleton arguments are so important. This is a quote from the best practice guide to asylum and human rights appeals. It's free on EIN. It's written, I think, by Mark Henderson and Alison Pickup. And I'd recommend anybody, even if you're not a member of EIN, you can get access to this. And if you've got people in your firm who work for you, encourage them to use this, to read it, because it's excellent. And it says this: if the judge has started with a negative impression of your case, that may affect his interventions during oral evidence. If his interventions leave your client and other witnesses feeling uncomfortable or believe the judge is leaning against them, it may affect their confidence and the quality of their evidence. That may in turn influence the judge's assessment of their evidence and reinforce any negative impression. It should not, of course, happen this way, but by providing a skeleton argument, you ensure that the judge has an accurate factual summary, is alerted to the real issues, and that misleading allegations in the refusal letter are answered before they have an opportunity to infect the judge's view of your client. So look at that, accurate factual summary. Look, these are the true facts of the case. The Home Office may have got it wrong, or maybe saying the client was inconsistent. These are the facts I rely on. Focus on the issues. You know, the Home Office raised all these issues, but actually these are the real issues. These are what's conceded. These are the issues, Judge, I say you need to decide. And then answer some of them in advance. So the judge doesn't have loads of questions on things which are actually already resolved and say, well, actually, if you look, maintenance is already met. This is already met. The only real issue is X. And you can narrow down the focus of the appeal. So there's a power of a good skeleton. I think it also emphasizes the need to get the skeleton in good time. So it's before the judge in advance. So when the judge is pre-reading, they've got your skeleton by the side of them as a guide to their pre-reading. So skeletons don't only affect the hearing itself, but actually a pre-reading stage. I've included some what I call advice from Desmond Browne QC. Desmond Browne is a leading barrister and a former chairman of the bar. And there's a paper published online which he gives some really helpful examples. So let me go through them. He talks about skeleton arguments. They're an example of getting your retaliation in first, of persuading the court of the merits of your case before the first words leave your mouth. They should aim to prepare the ground for the oral submissions that will follow. That's what my plan has always been, even before the new directions about when appeal skeleton arguments have to be. And I always tried to get my skeleton argument before a judge in advance so I can set the tone, that I can answer some of the questions in advance, that I can clear the ground, and actually then my oral submissions can build upon the foundation in the skeleton argument. It's the same actually with the Rule 24 response in the upper tribunal. If the Home Office have appealed an allowed decision, I always think it's so important to get a reply in, because then when a judge is preparing for the error of law stage, they can see, well, actually, no, that ground from the Home Office is just a disagreement, and see, you can get your response into the grounds in there before the actual oral hearing. Then try and present the court with a document which can be used as the basis of the judgment. You know, I've spoken to judges before who've indicated this. They rely on skeleton arguments to structure their judgment. In fact, I recently saw a brilliant example, and I can't take the credit. A solicitor of mine, and if you're listening, thank you very much, you know who you are, did a brilliant skeleton argument for a case. And when you read the judge's decision, you could see how she'd used the skeleton as a structure for her judgment. And when the case was appealed to the upper tribunal, I could go through the judgment and show how the judge had addressed every single issue and how there was a logical coherence to the judge's findings, because there had been a brilliant skeleton argument done, as I say, not by me, but my instructing solicitor. And here we go again. A skeleton not only needs to read well, it needs to look good. How it looks looks really does matter. Make it look enticing. Do you know that, again, this is, I've said this earlier, but this is something I've learned in preparation for the webinar, that how a document appeals is so important. Is it easy to read? When you see a cut and paste skeleton with 4 different fonts, with different sizes, with odd cut and paste stuff that you think is generic, it doesn't read very well. It's not easy on the eye. Make it easy for the judge to read. Have it logically structured. And he says here, group your paragraphs under explanatory headings, indicating the topic being covered. And if necessary, use subheadings. So you're providing that route map to the verdict that you want. Use those headings so a judge can clearly navigate through the document easily. Practical stuff now. Use wide margins and wide spacing of lines, at least 1.5. So I always use 1.5 line spacing in my documents. This enables the judge to write comments. Use a large font. Times Roman is commonly used, and use font size 12. I think he probably means Times New Roman is probably the most commonly used. And then he talks about the importance of pagination and using traditional pagination. So 1, 2, 3. And paragraph numbers, so 1, 2, 3, and then ABC for sub-paragraphs rather than 1.1, 1.2. So it makes it clear and easy to read. Put case references in the body of the document. Avoid extensive footnotes, because that makes it difficult to read and you're cross-referring down to footnotes. So if it's a point of substance, really it should be in the main text. And again, emphasizing what we said earlier from Susan Glazebrook, Desmond Browne says this: finally, proofread carefully. A third person will pick up typos, spelling mistakes and bad grammar much more they'll pick up spelling mistakes and bad grammar much more readily than the author. So as I said earlier, I sometimes miss mistakes in my own writing where somebody else would pick that up. Be clear and concise. This is a classic quote. I actually got it from the best practice guide off EIN from an old case called Zarura. And John Freeman, a tribunal judge, is saying this about Stephen Vokes' skeleton argument from number 8 chambers. And it's something I've learned from Stephen, his very concise skeleton arguments. And he says about the good thing that can be said about the skeleton argument, which it was short enough to make it reasonably clear how he put his case. This is usually not so with the skeleton arguments of counsel in this field, which are all too often so intolerably prolix that they may be better described as well-fleshed corpses doing more to conceal than reveal what the case is about. So is your skeleton an actual skeleton, or is it a corpse? Is it clear to see what your case is about? Where sometimes when you've got this over elaborate fat skeleton argument, a judge can't see what your main points are. And this was brought out by the Court of Appeal in the decision in M.E. Sri Lanka. Now, this is not a personal criticism of counsel involved, because I've certainly done it in terms of overly quoting long extracts from cases. So the Court of Appeal say this: of the 25 pages of counsel's skeleton argument, approximately 19 consist of quotation, some of which are themselves over 3 pages long. Where an authority is cited, the skeleton argument does not state the proposition for which it is cited. So if you're going to cite an authority, say what you're citing it for. So if you're saying, well, I'm relying on GM Sri Lanka, why are you relying on GM Sri Lanka? Well, I'm relying on GM Sri Lanka to say that insurmountable obstacles is not the test outside of the rules for proportionality. So give a clear proposition for why you're citing. There is no cross-referencing to any paragraph in either the decision of the FTT or the UT, or any attempt to explain why the FTT's findings of fact were inconsistent, which is the ground upon which permission was granted. So this is an appeal to the Court of Appeal, so you've got to cross-reference and say, well, look, there's the paragraphs in the FTT and the UT which are problematic and don't follow this legal principle which I'm citing. Despite a recitation of the asserted facts based on the evidence of ME and his witnesses rather than the FTT's findings of fact, there's only a single cross-reference to the bundle relating to a scarring map. That scarring map was not referred to by the FTT because it was common ground that Emmy had been beaten as he'd alleged. Most importantly, the skeleton argument failed to define and confine the areas of controversy by reference to the grounds of appeal, which does not mention at all. So you want this summary of the facts. You want to show what is in issue, what's the area of controversy, what's in issue before the court, and cross-referencing to the key documents, whether it's medical reports or it's the first tier tribunal decision. So as I said, we've seen the appeal skeleton argument become more important now as a result of the new practice directions we've seen coming out since the coronavirus pandemic. Now, we've all seen the FTT have sort of shifted their position. At first, the appeal skeleton argument was to be a comprehensive document, or that's what we all thought. Now this emphasis on a brief summary. This is the directions to represented appellants that follow Presidential Practice Statement number 2 of 2020. And this is for those appeals lodged using the online system. But you'll see the ASA must contain 3 sections: a brief summary of the appellant's factual case, a schedule of the issues, and the appellant's brief submissions on those issues, which should state why the appellant disagrees with the respondent's decision with sufficient detail to enable the reasons for the challenge to be understood. A template is available online. And we know it's important because now the ASA is not just for the appeal, but the respondent will review it before the appeal. So it may lead to issues being conceded. So I think an important structure now is to follow that summary, schedule, submissions, the 3 S's, and literally stick that up in front of you. Summary of the facts, schedule of the issues. Now, be clear with the schedule of issues. What's the convention, reason, credibility, risk on return? That might be it in an asylum claim. And also, when I do the schedule of issues, I also point out there what issues have been specifically conceded in the refusal letter. Then the submissions. And I think there you can cross-refer to the evidence and provide hyperlinks to case law. Clearly, they don't want now long citations. So you can hyperlink across to case law. Maybe with EIN Bundle Maker, you can do links to the bundle, so it takes you straight to the part in the bundle. So it says concise, numbered paragraph, engage with the decision, not extensive quotations from documents or authorities. But if you need to particularly refer, do, because sometimes it's only by referring to, say, a policy on homosexuals in Pakistan, you can show how there is a risk term and the Home Office policy pretty much accepts that. Identify but not quote from any evidence or principle of law that will enable the basis of challenge to be understood. So that's the directions coming out from the first tier tribunal. And interestingly, it does mirror the civil procedure rules. This is practice direction 52A of the civil procedure rules. And it says this: the purpose of the skeleton argument is to assist the court by setting out as concisely as practical the arguments upon which a party intends to rely. It must be concise, define and confine the areas of controversy. And that's what we saw the Court of Appeal emphasizing in ME Sri Lanka. Numbered paragraphs. Again, this importance of cross-referencing to the relevant document in the bundle. And that's the donkey work, because that often takes time, going through the bundle and cross-referring. Self-contained and not incorporate by reference to material from previous skeleton arguments. So all the arguments you wish to raise, make sure it's in that document, not include extensive quotations from documents or authorities. And where it's necessary, look at 4, where it's necessary to refer to an authority, a skeleton argument would state the proposition of law, identify the parts of the authority that support the proposition. And if more than one authority is cited in support of a given proposition, the skeleton argument must briefly state why. Let's move on thirdly then to grounds of appeal. And being appealing is my subheading here. And we want to gain permission. We want to see our appeals successful. And the biggest issue and the sort of headline in this area is avoiding the sort of long, rambling disagreement. Sometimes when we're vexed by a decision, we want to go into a long rant of why we think the judge was wrong or why we think the Home Office were wrong in their decision. The danger is there, we just end up with a long disagreement which doesn't identify an error of law. So that's the big issue I see there, and the challenge which I think this shows us. Let's look at the types of grounds we might come across. Well, there's grounds from a Secretary of State's decision or an ECO decision. Now we're seeing the online procedure. They're less important because often it's a tick box affair, but do raise issues. If there are sort of human rights grounds and articles that you need to raise, make sure you raise the appropriate grounds so everything's covered and you're not excluded from something, or by the time you get to the upper tribunal don't say, oh, well, that was never raised in the original grounds. The most common thing we come across often is permission to appeal grounds from a first-tier tribunal decision, whether that's grounds to the FTT for permission or renewed grounds to the upper tribunal. We may, when there's a decision without an appeal, have a option of administrative review. And there we want to show that there's a case working error in the decision. You may draft judicial review grounds or CART judicial reviews where you have to show a public law error. Or you may have to draft grounds to the Court of Appeal and the higher courts. Let's focus particularly on two: the permission to appeal from a decision of a first-tier tribunal judge. This is the Joint Presidential Guidance 2019, and it says this: it is reasonable to expect a professional representative to set out the basis of the application for permission to appeal with an appropriate degree of particularity and legibility. So, focus your challenge. The parties are under a duty to assist the tribunals in their overriding objective and cooperate with them. For those reasons, a judge is entitled to expect that the grounds of appeal should set out in simple language, again, see that common theme, clearly and concisely why the decision of the FTT was wrong, that they address the relevant part of the decision and the way in which it is said to be wrong in respect of each way in which the decision is said to be wrong. So, a specific attack, this is where I say it's wrong in these three reasons. A judge is entitled to point out where this has not been done. The judge's role is to evaluate the claimed errors, not to read through the overlong grounds padded out with unnecessary quotations from statute or case law to discern if they disclose an arguable error. So as we saw with skeleton arguments, that judges don't want to see these sort of long quotations. Now, don't get me wrong, when there's a need to cite a proposition, you may need to put a particular quote in and there may need to be something there, but these pages of quotations are frowned upon. What about renewed applications? If the FTT have refused permission and you applying direct to the upper tribunal, what do they say? An application to the UT for permission to appeal is a fresh application and must include, and the emphasis there, all the grounds on which the appellant seeks to rely, including those contained in the application to the FTT. It is sufficient to say that those grounds are relied upon. But if the grounds set out in the first application are not included in the renewed application, a judge is entitled to assume that the applicant no longer wishes to rely on them. This should be recorded in the reasons for the grant or refusal of permission. So when I come to do upper tribunal grounds, what I tend to do is actually I cut and paste, often if it's my own grounds to the first tier, cut and paste and say, these are the grounds that were submitted to the first tier. These grounds are specifically relied upon, and I make the following observations or additional matters. Now, if you didn't draft the original grounds and you think, well, hang about, these original grounds, I don't like ground A, but I think ground B and C have merit. You could say, well, ground A of the grounds submitted to the FTT is not relied upon, but grounds B and C are and do raise an arguable point of law. Paragraph 33, an application to the upper tribunal is not an appeal against the decision of the judge who considered the application to the FTT and should not be drafted in that way. And I've seen that recently. I've seen some renewed grounds where it's framed as an appeal against the judge who refused permission. That's not right. But it is sometimes helpful for applicants to say why they disagree with the reasons given by the FTT for refusing permission, but it is never obligatory. So I usually engage with the judge who refused permission without coming across like it's an appeal against that judge in order to show why my grounds are arguable and why permission should be granted. The guidance carries on. A complaint with an assessment of facts that it was legitimate for the FTT judge to make cannot normally be characterized as an error of law. So just if you're complaining about what a legitimate view of the facts is, that's a disagreement. A judge is entitled to reach a different view to you on the facts. If it's not irrational or perverse or doesn't contain any legal errors, that judge is entitled to make that decision, and that's a disagreement. 2, whilst disregard or misstatement of evidence that was placed before the FTT may amount to an error of law, or a failure to act fairly, the submission of further evidence following the hearing to contradict a finding cannot usually be said to be an error of law, unless you can satisfy the E&R criteria. So you can't just say, well, hang about, actually there's this evidence that we never submitted, that shows there was an error of law. If there's new evidence, usually it has to be a fresh application unless you can satisfy the criteria in E&R. Obviously, if you do get permission and an initial decision is set aside, when the upper tribunal come to rehear the appeal, then you can put in new evidence with permission. An error of law in the decision being challenged on a topic that is completely irrelevant to the substance of the decision in hand is unlikely to justify the grant of permission unless the point is of general importance. So look at that. It's got to be a material error, i.e. it's got to make a difference to the outcome of the case. The fact you may spell my name wrong is an error, but it doesn't make a difference to the outcome of the case. It's got to be material. Roman 4, a point of law that is not arguable, whether because the statute is clear, the contention extravagant and unsustainable, or it is stable binding precedent of the higher court, is unlikely to justify the grant of permission. However, if there's a case for the upper tribunal higher courts to reconsider the point in issue, permission should be granted. Now this talks about points of general importance, but he says, look, that's going to be rare when it's a point of general importance. So even though, look, there is binding authority, but we think we need to revisit this issue. Don't frame every set of grounds you draft as a point of general importance, or judges will quickly realize that your grounds are not serious. So if you do think there is a general point of importance, even though there might be authority the other way, then engage with it specifically and deal with it head on, but save it for the real ones where there are those kind of issues. What is an error of law, or an error on a point of law is the language that's used now? Well, it's set out in the case of Iran. And you'll see there in those 7 Roman numerals on your screen are common errors of law that are usually encountered in practice. And what I use those 7 errors for is I use them as headings. So when I'm drafting my own grounds for permission to appeal, I'll say, appeal was heard by Judge Bloggs on this date. Judge promulgated the decision dismissing the appeal on this date. Permission to appeal is sought to the upper tribunal. If there are any facts conceded or other things I feel I need to set out, I might set out that in a paragraph, but I'll then say, the judge made the following errors of law. And then I'll say, 1, making a perverse finding. And I'll use that as a heading because what I want the judge to think, oh yes, that's one of the Iran errors of law. That's not pipe just disagreeing. That's an error of law. And then they think, oh yes, right. What's he saying? And then I illustrate. So I'll say at paragraph 25, the judge said this, where actually that's not a finding they were entitled to make, given that issue was conceded or there was evidence on this issue at page 99. So what are the common errors of law? Perverse or irrational findings on material matters. So findings that a judge was not reasonably entitled to make. Remember, that's quite a high bar. Failing to give reasons or adequate reasons for findings on material matters. We're going to come back to that in a minute. But a lack of reasons must be on significant issues. Failing to take into account or resolve conflicts of fact or opinion on material matters. So if they haven't dealt with certain issues, if there was expert opinion on certain matters that they haven't dealt with, or if there's stuff they just haven't taken account of that was material to the outcome of the case. What about giving weight to immaterial matters? Now, look at this. This is not just a challenge that we don't like the weight the judge put on a matter. This is giving weight to matters that the judge shouldn't, immaterial matters. And that's an important distinction. We'll come back to weight in a minute. Making a material misdirection of law on any material matter. So if a judge applies the balance of probabilities in a refugee claim, that's a material misdirection of law. Committing or permitting a procedural or other irregularity capable of making a material difference to the outcome or the fairness of proceedings. Now, often procedural irregularity cases need evidence and often witness statements for advocates. And you may think, actually, I shouldn't be drafting the grounds in this case because I was the advocate. And actually, I need to do a witness statement and refer these grounds to a colleague. And then making a mistake as to a material fact which could be established by objective and uncontentious evidence where the appellant and or his advisors were not responsible for the mistake and where unfairness resulted from the fact that a mistake was made. And there's the E&R test again there in relation to new evidence. So what about materiality? An error must make a difference. Now, in a recent video, I've talked about this case from January 2020, the case of OK. That was a Ukrainian female asylum seeker making a draft evasion claim. She was refused on credibility and the judge didn't think she would be called up, so wouldn't be treated as a draft evader. But the judge made an alternative finding that even if she was a draft evader, she wouldn't be at risk of persecution. And the representative drafted, I think, long grounds. I think there were 7 grounds in all. They got permission, but it didn't challenge the alternative finding. So any challenge was bound to fail because there was this unchallenged finding that the appellant wouldn't be at risk in any event. Now you can see at paragraph 15 there on the screen, the tribunal weren't impressed with the grounds and they weren't particularized and legible. You know, that's going back to the guidance. They misrepresented observations and elevated them to findings. So the tribunal were very critical there, but they make the point of paragraph 16. Look, if there's an unchallenged finding, you shouldn't really get permission to appeal because any grounds are bound to fail. So make sure your challenge is material to the outcome. Are there alternative findings that you need to engage with so your challenge has legs? Weight. Now, one of my rules in grounds is don't challenge weight. Because if you challenge weight, you've got to be more subtle about it. If you challenge weight, you're just going to be told it's a disagreement. It's not for you to say, well, a judge, the weight they gave to that was wrong. Because as long as a judge didn't act irrationally or perversely, they're entitled to give a certain amount of weight to evidence. So look at Roman 2 there. Permission should only be granted on the basis the judge who decided the appeal gave insufficient weight to a particular aspect of the case if it can properly be said that as a consequence the judge who decided the appeal has arguably made an irrational decision. And then what they cite the Court of Appeal saying what we must guard against is they're not in fact disguised just disagreements. So you've got to show that actually if it's a weight challenge that the judge was irrational in their approach. Now, Roman 3, when I was preparing this, made me laugh because I caught myself using this kind of language in grounds. Particular care should be taken before granting permission on the ground the judge who decided the appeal did not sufficiently consider or sufficiently analyze certain evidence or certain aspects of a case. Because again, it's a disagreement. And sometimes when I want to challenge weight, I'll say, oh, well, the judge didn't sufficiently consider this aspect. Again, watch that language because that can be interpreted as just disagreeing with a legitimate finding. You've got to show, well, either the judge was irrational or the better approach is a judge did not take into account a material piece of evidence which undermines the findings that he or she has made. And they're only going to grant permission. Look at the final sentence. And permission should usually only be granted on such grounds if it is possible to state precisely how the assessment of the judge who decides an appeal is arguably lacking and why it is arguably material. So you've got to be very particular and careful in how you articulate such grounds if you're saying, well, they haven't properly considered this evidence. What about a reasons challenge? reasons was one of the Iran errors of law, but reasons are, you have to be careful when advancing a reasons challenge. VV sets this out. An application for permission to appeal on the grounds of inadequacy of reasoning in the decision of the FTT must generally demonstrate, by reference to the material arguments placed before that tribunal, that A, the matter involved a substantial issue between the parties, and the tribunal either failed to deal with that matter at all or gave reasons on that point which are so unclear that they may well conceal an error of law. I suppose this links back to our skeleton arguments. If we've set out the issues that we want the tribunal to resolve, and we've shown the evidence that backs up what we say is the way we want the judge to find on those issues, we can, if the judge doesn't engage that at all, you can say, well, look, in the skeleton, this was the issue, this was the evidence supported in advance, and the judge just hasn't considered that, and there are no reasons properly for the judge's finding. And then 2, given that parties are under a duty to help further the overriding objective and to cooperate with the upper tribunal, those drafting grounds of appeal should proceed on the basis that the decisions of the first tier tribunal to be read fairly and as a whole without excessive legalism. B, should not seek to argue that a particular consideration was not taken into account by the tribunal when it can be seen from the decision read fairly and as a whole that it was, and the real disagreement is with the tribunal's assessment of the evidence or the merits. And C, should not challenge the adequacy of reasons given by the FTT without demonstrating how the principles in one above have been breached by reference to the materials placed before that tribunal and the important or substantial issues which it was asked to determine in that particular case. So look at the decision as a whole and show that the judge hasn't resolved or given reasons for a particular issue when looking at the decision as a whole. And again, guard against this disguised disagreement. If it's clear that the judge has taken into account issues, you're not going to get very far. Finally then, what about judicial review grounds? Well, remember, when challenging a decision by way of judicial review, it's a public law error that we're looking at. So public law errors are illegality, irrationality, and procedural impropriety. It's not closed categories, but they're generally the heads of public law errors. And remember, in human rights claims, in judicial review, the court can look at proportionality for themselves. The Court of Appeal have confirmed this in Karupan. So this is language in SN, the case on your screen from you recognize the language straight away. It's Mr. Justice McCluskey. And he clearly says in this, well, look, it's good practice in your grounds to list the public law errors in a single paragraph. So set out what's the target of the challenge, what are the errors, and then paragraph 31, provide particulars and the supporting evidence. So what I tend to do is in my ground section, I'll set out a summary paragraph that the Secretary of State hasn't properly assessed insurmountable obstacles and they're irrational in their approach and there's no consideration of Article 8 outside the rules. Then I'll do some separate subdivided grounds, and then in each one I'll show, well, actually in insurmountable obstacles, they haven't looked at X, Y, and Z. So what's your target of your challenge? What's your summary of the errors? And then set them out and particularize them. So a judicial review grounds template from me. This is not the final word on the issue. An introduction, what's the decision targeted and the remedy sought? Be clear, what is the target of the decision? And judicial review is not a rolling review. So what is the decision under challenge? What remedy do you seek? Then set out the relevant facts. We're going to come to our duty of candor in a minute, but include all the relevant facts. What are the relevant legal provisions? So actually, in this judicial review, the relevant legal provision is EX1A and 276 ADE. Set those out and set the correct version of those out. Then what are your grounds of challenge? And going back to that quote from Mr. Justice McCluskey, give a summary paragraph and then follow them by numbered grounds. So ground 1, failure to properly consider insurmountable obstacles. Ground 2, failure to assess Article 8 outside the rules. And then a conclusion or a prayer. You know, we say for these reasons, the decision is flawed. The decision should be quashed. The Secretary of State should reconsider And don't forget to ask for costs. And don't forget your duty of candor. Duty of candor is so important in judicial review. So if there's been previous determinations, make sure you record them in the statement of facts. You may need to include them in your JR bundle, deal with them in your grounds. But actually, you can turn that as a weapon to your advantage. So again, Justice Susan Glazebrook, while your role is to persuade, this must be done in an ethical manner. So you have a duty to put before the court contrary authorities and not to misrepresent the facts or the law. So if there's a decision against you from the Court of Appeal, deal with it. Candor more generally can be seen as a powerful weapon of advocacy. Know and deal with the weak points of your case up front. So say, well, actually, yes, these are the weak points. There are these decisions, but there is this further evidence which shows that I have a sustainable fresh claim for asylum. Do not leave out inconvenient facts, but try and place them in the best light. The same applies to contrary authorities. So I hope this webinar has been helpful to you. We've covered the drafting of representations, we've covered the drafting of skeleton arguments, and we've covered the drafting of grounds. And we've talked a lot about being clear, being concise in your drafting. And I hope this is of practical use. Now, in the live webinar, I'm going to deal with questions at this point, but here are my contact details for those who need to get in touch with me. I hope it's been helpful, and I'll see you on the next video.